Welcome to Case by Case. This is a podcast brought to you by Luke Djokovic and Calum of Djokovic. How are you today, Calum?
I'm very well, Luke. How are you?
I'm good. This is a fun one to be doing on my holidays.
The commitment.
The commitment, exactly, the commitment. Look, I enjoy these. I really do. I don't find them a chore at all. And this case today is no different at all. It's a real juicy one, a big fun fight over not much money, frankly, in the scheme of things, in the High Court of England, the Commercial Court. And we have a judgment that was handed down only recently on the 10th of August 2022. Parties' names are Eastern Pacific Chartering as the claimant and Polar Maritime Limited as the defendant. It's a case we've touched on before on jurisdictional grounds. At a time, I think we just get straight into this one, Calum.
Yeah.
But I'm looking forward to it. I really am.
Yeah, and I think the first thing I would mention is that this is a very shipping case for two reasons. They're basically the judgment has two key parts to it. One is speed and performance, which is maybe as kind of shippy as you can get almost, and the other is wrongful arrest. Each of those components makes this a great one for our listeners in the shipping industry and the shipping markets. And equally, it was, I thought, very interesting that they had Ms. Claire Ambrose sitting as the deputy judge of the High Court for this one, because she is obviously someone who is phenomenally experienced in these specific kind of shipping issues, and has written a number of papers on, shipping arbitration and shipping disputes practice. So unsurprisingly, she was all over the details on this one.
Absolutely. And really, I know we say this quite a bit, but highly recommend reading this decision if you've got a speed performance claim, or indeed if you've got a wrongful arrest type claim.
Or if you're about to go for an arrest, which is a little bit on the edges.
Exactly. Or if you're about to go for arrest, or if you've got clients who are concerned about bringing arrest and they're wanting to know the test for whether it might be considered wrongful or not. We get that question a lot when weighing up whether to arrest a ship, and we'll get into that in a moment. But really, if you have a speed performance claim, read the judgment. If you've got an arrest you want to bring, you want to challenge whether it's wrongful, read this case. It's really a good case. One question that struck me before we get into it, into the meat of it, is why do we have a decision? Why has this gone all the way on such small amounts?
Yeah, and on such technical issues, I think that's the other thing. The cost of running this would have been high because you needed a lot of expert input on the speed and performance issue. There was a lot of foreign law involvement on the wrongful arrest issue. But at the same time, if the parties can't see eye to eye, then there's not much that you can do to make them. It's one of those where people take a position, and it might not be the kind of $1 million claims that perhaps we often see going all the way to the courts, but sometimes there's just a point that parties can't get past, and then by the time by the time it's moved a certain distance along in the procedural process, there's more costs behind it. There's more entrenched positions. There's a lot to be said in this for the early settlement. The sooner you can get it done, particularly with a claim that has small quantum, the earlier you can get it resolved, better, because that means that your costs don't then become a sizable portion of the quantum.
Yeah, exactly. We don't ultimately know what happened on costs. That's not dealt with in the judgment, but I think that would make for very interesting reading. My take on it was I just wondered whether there was a wider context to this one, whether there was an arbitration up the chain, because we were dealing with, as claimants, the disponent owners and the charterers below them. And in that charter party, so the charter party, the subject of this decision, there was an exclusive High Court jurisdiction clause, which is not that common. Typically, it will be an London arbitration LMAA clause that's in the charter party, or indeed other jurisdictions around the world. Particularly, it will be an arbitration decision or arbitration agreement, not an exclusive court jurisdiction clause. And that was interesting. So they may not have been back to back on the forums. So they may have had an arbitration agreement up the chain and a court jurisdiction clause in this charter party down the chain. And what they needed was actually a finding in the court proceedings that they could then take into the arbitration up the chain. That's complete speculation. I don't know that. There may not be an arbitration, but I wondered whether that might be part of it.
It's entirely possible, and I think actually although it's rare that you see these types of issues before the English High Court, particularly speed and performance, there is an awful lot of material from the LMAA reported the LMAA summary judgments or summary awards on speed and performance, and particularly on an issue that rose here on whether you have to apply a current factor for a positive current. And it's nice that this one went to the English High Court because we now have something to kind of tie a knot on this, maybe 8, 10 awards that have come out in the last 10 years or so that touch on this, and they go a number of different directions, and each turns a little bit on the specific wording of the Charter Party. But at least there's some good guidance now from the High Court on the way that the law is going to progress on speed and performance.
Yeah, absolutely. Because this is a decision of first instance. Usually when we're seeing decisions from the English courts, it's because they've been appealed on a point of law from an arbitration award. Anyway, really interesting as to why, a lot of speculation in there. I also wonder whether there was just bad blood because of the nature of the wrongful arrest, people getting alleged wrongful arrest, I should say. And that may well have led to entrenched positions, and they just struggled to resolve it because after the first court decision on jurisdiction to hear the wrongful arrest claim, which ultimately was allowed to be heard. That's why we have this decision on that point. There was some encouragement to go off and mediate. I think it was at the CMC as well. The parties were encouraged to go off and, explore ADR to see whether the matter could be resolved. And a mediation did not even take place, I think it said. So they were pretty entrenched in this one.
Yeah, indeed. So where do we go first? We've got two options. We've got speed and performance, or we've got wrongful arrest. Which one do you want to tackle first?
Let's do it the order that the judge has done it. Let's tackle speed and performance first, eh?
Yeah, that sounds sensible. So this was basically a balance of account issue. There'd been deductions made by the defendant on the basis of a failure to achieve the speeds that were set out in the Charter Party, and the claimant was therefore claiming for a balance of account. So strictly speaking, the defendant was the one claiming a breach of the speed and performance warranties, or a breach of the obligation to proceed with due dispatch, or alternatively, the obligation to deliver with a clean hull. And I think also claiming an off-hire for time lost due to a defect in hull. They're the defendant in the case, but really they're the ones pursuing this claim. And
yeah, because the disponent owners, they brought their claim for unpaid hire, and the defendants, the charters, were arguing up the chain that they didn't have to pay hire, or that there were damages for breach of performance warranties. So it was actually kind of reversed in a way in terms of the analysis.
Yeah, exactly. And for me, the most interesting part of this was the current factors, because that's the part where I've looked at the law on this a couple of times recently, and until now, you can't really advise in a way which is that straightforward, because the arbitration awards, at least the arbitration awards that are summarized and published in that way, they go back and forth on this. And I have to say, reading this judgment changed my mind about what the correct approach is. Effectively, starting from the start, there are kind of two ways of looking at this. The first is that if you are a ship owner and you give a warranty of performance in good weather, and in that warranty you say no adverse currents, then the question is, if you're steaming along and you manage to achieve the speeds at the efficiency that you say that you're capable of achieving, but you do so with the benefit of a positive current, then when you go through the calculation to take into account the vessel's performance, is the charterer entitled to say, well, we have to adjust that calculation because you had the benefits of a positive current? And there's been decisions back and forth on this. Obviously, if the charter party is clear on that, then it's fine. There's no discussion. But most charter parties that I've seen will have an express exclusion for adverse currents, but they'll be silent on positive currents.
Yeah,
yeah,
exactly. And the position with the currents, and we had two two leading experts in this case for each of the parties, and they were both commended on the evidence they gave. There's one part of one of the reports that came from another expert within the team, but I don't think we need to get into that. But a lot of what they had to say was not in dispute, but there was obviously quite a bit that was. But one of the areas on this, the current analysis, is that it's actually difficult to assess the direction of the current, right? When you think about it, like how do you know if the current's completely in a positive direction, or is it just slightly off? And maybe there is some friction associated with it, but there's some benefit. And I thought on the technical side of it that it was quite interesting actually that when you're looking at positive currents, it's somewhat difficult to actually assess the positive currents, and there's an open question as to whether reporting companies are reporting them with sufficient clarity, enough data to be able to give reliable indications as to what the positive current allowance should be.
Yeah, and this was the first thing that came up that I wasn't aware of, that yeah, quite how difficult that was, because normally when you see these weather reports that are prepared by these weather companies, you can see quite clearly what that they set out what the current is as far as they're concerned. So I always
Yeah.
assumed that it was kind of that black and white. Clearly, it's nothing like that black and white. And the second factor that one of the experts mentioned was that actually there's some navigational technique in finding positive currents, and there's a good argument, I think, that the owners, or the vessel, perhaps you could say, should have that credit if it's almost part of the performance of the vessel is having a master who's able to navigate using currents in a way that that's favorable to the route and favorable to everybody. And there are a whole host of reasons why that would make good sense. And it's, almost a good matter of public policy that, the parties should endeavor, obviously, to try and reduce their, make the ships as efficient as possible and go from A to B in a manner which is as efficient as possible. And actually there's that it's not just a kind of vicissitude of fortune whether you hit a favorable current or not. There's some, navigational skill that goes into finding a positive current and using that to assist the vessel to proceed efficiently.
Yeah, and it shouldn't be held against them. Like there
Exactly.
should always be an encouragement or an incentive to find those positive currents, because it's really in the interest of everyone involved, owners and charterers.
Yeah, exactly. So the judge was persuaded, as I was actually reading this, by those arguments, and said actually if the charter party is silent on currents, then you do, as an owner, you do get the benefit of the positive current. You don't have to adjust for it. And previously I'd thought this probably should go the other way, because the speed and performance warranty, to me, is not saying that the vessel will go at that speed in those weather conditions. It's saying the vessel that the service that we're providing is a vessel which is capable of this performance. And if it's only capable of that performance with the benefit of positive current, then my previous view was, well, in that case, it's not capable of that performance because it's
Mm,
it needs the help. But actually, reading this, I do think there's a number of reasons, the ones we've just gone through, to say actually no, if you can achieve those speeds, then you should be encouraged to do so, however you want to, or however you're able
yeah.
to.
Yeah, yeah, I thought it was an interesting part of the decision actually, and it's a good one, as I said before, to see how the expert and technical evidence is being presented, how what swayed the judge, how to kind of lead this evidence, if you like, if you're a practitioner in subsequent cases, and how it should be presented, and where are the points to kind of focus on. I thought there was some really instructive kind of ways in which this played out. The other
Yeah.
area that I thought was quite interesting on the speed performance side of this dispute was the possibility of having different methods for assessing whether a vessel has performed or not. And what you've been talking about there, which is the common approach, and the one that's used in practice day in, day out, is the good weather method, where you take a period of time during which there is good weather, and often it's difficult to find that period, but sufficiently long enough period where there's good weather, you look at, could the vessel meet its warranties of performance, speed, consumption during the good weather period, and then you extrapolate that out over bad weather periods as well. Makes a lot of sense, easy to apply. What if, though, there are no good weather periods? In this case, the argument was, well, in those situations where you can't, when you don't have the benchmark, when you don't have the period of good weather to assess whether the vessel is meeting its performance or not, that's it. You don't get you don't get an underperformance claim because it's not possible, evidentially, to make out that claim.
Yeah.
And the discussion here was, and it was argued by the charterers, well, no, there's another method by which you can assess underperformance. And they argued in the alternative that it was this RPM method where you look at whether you look at the RPMs that the vessel was reaching here. I think it was around 92 or not above 92 RPMs. And the expert argued that 96 would have been what it needed to be hitting to reach the speed. And they had a complicated equation to work out what the RPMs should have been to meet the speed and what the speed actually was over this period, and working back using the RPMs actually achieved to say, well, it was underperforming. And it may not have been underperforming. It wasn't, charters argued, it wasn't underperforming because of the weather. It was just running at lower RPMs, and there was no way it was going to get to the warranted speed at those RPMs. And so then what the court did was explore, well, is it possible to have an alternative method? Question number one. Question number two, was the alternative method, if so, was the alternative method pleaded here a good one or not? And let's talk that through. But I thought that it was really interesting, actually, for the court to conclusively look at whether it's possible to bring an alternative method. And the answer is that it is possible, and you can make out underperformance claims in methods other than the good weather method.
Yeah. And this also goes to, often you see a claim for underperformance twinned with a claim for failure to proceed with utmost dispatch. And this kind of covers you off from that other angle as well, because you can say, well, the engine, the RPMs simply weren't fast enough for it to have been possible for the vessel to go at the speed required. And that's a failure, by the master and crew to set the engine to an RPM that would be capable of achieving the speed that the owners have warranted the vessel is capable of doing. So it's interesting in covering off that point. And I think more broadly, if you look back through the law on speed and performance, it does always, as this one has really, tend back to the kind of conventional way of looking at speed and performance, which is as you establish whether or not the vessel underperformed in good weather, and absent words to the contrary, you extrapolate that underperformance across the period of underperformance, even in bad weather. And that's ultimately how it happened here. But all of the authorities are clear to say this is not the only way that you can establish a breach of this warranty. This is just the way which is most sensible and, well, easiest if you have good weather, but it's not the only way to do it.
Yeah, and the difficulty here on the alternative method, so this RPM method, was that the judge found that it just wasn't sufficiently reliable in the facts of this case. I don't think it wasn't a finding to say you couldn't use the RPM method in any case. You probably could, but you needed to deal with a few other evidential issues and lead evidence on them to get around some of the unreliability aspects of the RPM method. And I thought it was quite interesting. So, if you're in a case where you're struggling to find clear weather, but you really do think that there was either failure to prosecute the voyage or there was underperformance for some other reason on the owner's side, that you can sit down with your expert and work through, well, is there another way that we can make this out? Is there another way evidentially that we can make this out? And on evidence, I thought it was interesting that the master wasn't available again. Maybe that goes to the disponent head owner's point. Maybe they didn't have control of the master to be able to present the master. But we've had cases, haven't we, where we might be on the charterer's side and the master's not available to give evidence. And it does put the owners in a difficult position if they don't have someone evidentially turning up to actually explain why they did this, why they did that, and defending their position.
Yeah. And there's one other point on the speed of performance angle in this case that I think is quite interesting, and I think this judgment gives an answer on it, although not directly. And so the reason in this case for the underperformance appeared to be hull fouling, and that's why, for example, a claim was raised for a breach of the obligation to deliver the ship with a thoroughly efficient hull. Now, there are two things. One is a breach of the speed and performance warranty, which means that you're unable to go at the speed that you warranted. But the second is a breach of the obligation to deliver with a thoroughly efficient hull. And there's an open question, in my view, as to whether the damages for a breach of a failure to deliver with a thoroughly efficient hull are the same as the damages for a breach of the speed and performance warranty. Because technically, you could say that what you should be looking at for that clause 1 breach for the failure to deliver with a thoroughly efficient hull is what would have happened, how fast would the vessel have gone if we had delivered with a thoroughly efficient hull? And that's not necessarily the speed and performance warranties. And this has come up a couple of times in cases that we've been involved in. So say, for example, there are two stages to a voyage. If the vessel's delivered with an unclean hull, it goes halfway, it then has hull cleaning, and it then outperforms speed and performance warranties for the second half. If you look at the first half of the voyage, where you have a claim for either underperformance or for breach of the obligation to deliver with a thoroughly efficient hull, then is your claim for this breach to deliver with a thoroughly efficient hull, is it based on the difference between the speed that you went at and the speed that you warranted, or is it based on the speed that you went at versus the speed that you ultimately then went at with actually a thoroughly efficient hull? And it looks here as though the judge basically said, well, they'd all come to the same place anyway, which I think is the right decision, because I think that probably the level of efficiency that the hull would need to have to comply with clause 1 or to not be an off-hire event under clause 15 of the NYP form would be a hull which is efficient enough so that the vessel can meet the speed and performance warranties.
Yeah, yeah, and you got to read the two together. I think that's right. I think that's right. That makes sense to me. Right. Okay. Yeah. There's a lot in there. There's a lot in there, and there weren't a whole lot of hours in dispute. What were we talking? 16 hours, I think, ultimately.
Ultimately, 16. Ultimately, they found that it underperformed to the tune of 16 hours. I think that the defendants were going for more, but I think they got 16 hours, and I think the rate was, going off the top of my head, I think it was around about 18,000 a day for the ships. So
Yeah, well, there was a double recovery argument. They were
Yeah.
trying to get the hull failing on top of the underperformance. That was struck out on a double recovery basis, and there was some other points in there as to why it was cut down. But yeah, so not much really in dispute, but we've got a really interesting decision. Thankful for the parties for running it to give us the decision, I suppose.
Well, exactly.
Should we skip on to wrongful arrest?
Let's look at wrongful arrest, because I think there's the question here really is, how wrong does an arrest have to be wrongful?
I like it. I like how you put it.
Because this arrest was straightforwardly wrong.
Yeah.
They arrested
Yeah.
someone else's ship.
Yeah, and also what can you rely on, right? Just to paint the picture here, the disponent owners brought an arrest against a ship that, let's just say, was associated with the charterers in some way, and they relied upon Lloyd's investigative report that described the charterers as the beneficial owners. And I say that loosely. There was a dispute about what the report actually said and didn't say, but there was enough in the report for the disponent owners to argue that this other ship, the Polar Devourer, was beneficially owned by the charterers. They went to Gibraltar, arrested this other ship. The charterers turned around, and there's some nuance on this about different lawyers representing different parties turning up and saying different things. But essentially what happened was they turned around and said, well, no, here are the registry extracts. We're not involved in that ship. It's owned by a different entity. There's no beneficial ownership. There's some chartering connection, sure, but from looking at the actual ownership, the charters are not involved in that ship. this arrest is wrongful. They offered an LOU, which responded to only the owners that were involved in the other ship, which was pretty much useless to the claimant disponent owners here because they have a claim against the charters, against Polar Maritime Limited. And the LOU was offered for the owners of the other ship. So they said, no, we're not going to accept that LOU. There was more toing and froing between the parties, and ultimately the disponent owners backed down and said, okay, we're gonna let the ship go, we'll release the arrest. They were basically persuaded that the actual documents show that Polar Maritime Limited, the charterers, were not the beneficial owners of this other ship. Security was then agreed 10 days later or some moment later after this other ship had been released. We don't have the details about, whether anything else was done to get that security, but sense prevailed. Security was offered for what is a relatively small sum. But the other ship had been arrested. It lost time. There'd been some other losses kind of down its chain that had been brought into the mix as well. So the charterers in their counterclaim in these proceedings were saying, well, this other ship has suffered losses. We're bringing that as a counterclaim. And so the question was, well, when the disponent owners relied upon I think there was actually two bits of evidence from C-Web and also Lloyd's that suggested the charterers were connected with the other ship. Was that done in an honest way? Was it done reasonably, such that it was not wrongful? And that set up the analysis of, well, what is the test for a wrongful arrest?
Yeah, exactly. And it seems like there's this two-stage process, and the one which is the one which really this turned on was whether they could show this, crassa negligentia, the kind of gross negligence level, or alternatively a finding of malice in what the arresting party had done. And it was a really interesting discussion, and I thought that the obviously, Ms. Ambrose will have been involved from time to time, presumably on advising around these arrests, and clearly there was there was a very good understanding of how it works, and the fast paced nature of going for one of these arrests, and the back and forth emails, and the party saying, no, you've got the wrong ship, and the other party saying, give us the security, we need the security to get the release. And then finally you get these documents that prove that the arrest is not correctly made. And very swiftly after that, the ship's released. And I think ultimately, reading between the lines, that was pretty critical here to the decision, was that when the defendants showed that the vessel had not been correctly arrested, the arrest was lifted in very short order. And I think that gave some sympathy, where the judge had some sympathy there with the arresting party, because clearly the judge felt that it's reasonable to try and hold on and make the most of your arrest until you see clear proof that the arrest is not going to be upheld. And at that point, to move swiftly to release it doesn't mean that you've satisfied this this threshold of malice or gross negligence in making the arrest.
Yeah, exactly. So essentially the party arguing that an arrest was wrongful such that they're entitled to damages, they need to show malice or gross negligence. And here, the arresting party had publicly available information that suggested that the party that they were going after was involved in the beneficial ownership of this other ship. Now, we know that, and I'm sure the judge, this guided the judge to some extent, that it is possible for owning entities to clarify with these reporting agencies out there what the actual ownership was. And what was reported, even on the registered ownership side of things, wasn't accurate here. And that was a point that was instructive for the judge, that the owners hadn't actually properly updated the reporting agencies, if I can call them that. And also, I think there was this overriding view that came through, not a formal view, but almost sentiment that's pro-arrest. And when you think about it, I think it's absolutely right that for parties in a charter party situation where their counterparty has assets that move all over the world, the other party may be based in a different country. Enforcement issues are real. And there's this whole body of arrest law around the world, different jurisdictions that give availability of arrests. And parties should not be deterred from bringing arrests for security for their claim. And now this wasn't formally part of the decision, but I found it was part of the flavor of the decision in that if there's reasonable evidence to rely upon to go and get an arrest, you go and get the arrest. You're not going to be punished for it as long as you're not acting with malice or grossly negligent. You're not going to expose yourself to wrongful arrest damages. Then, of course, if the other party turns up and says, "Look, you've got it wrong. You've got the wrong party. Here's the proof." If you then reflect upon it and say, "Okay, fair enough, release the vessel," you're not going to be stung with damages. And I see that as a pro-arrest type view. And in my personal opinion, I think it's absolutely the right one.
I agree, and I think you have to factor into that the way that the market works, and there did seem to be some association between the target company and the entity that actually owned the ship. But as we know, in the in the market generally, there is the practice of having ships owned by by individual ship owning companies, and that all makes it more and more difficult for a party to secure a claim. So if the courts are a little bit on the side of, well, there was enough for you to have a go, and when you found out, categorically that you were wrong, you withdrew the arrest. I think there's good sense to that from a just public policy perspective.
Yep, totally agree. Totally agree. And look, when I got to the end of this one, I was like, okay, so well, actually, before I read through the whole case, I wanted to get a bit of a steer as to who ultimately won this one. And I jumped to the end, and I was like, oh, okay, there was a finding in favor of the charters. They made a recovery on their 16 hours. And then I thought more about it. Well, they actually lost on the wrongful arrest. They had their speed and performance claim cut down on a numerical sense, at least more than half, I think. What would have been the ultimate result on costs on this one? It would have been a really fascinating discussion on costs. I'm not sure we've got time for it today, and I don't think we'll find out about it unless this goes further, which I highly doubt. But look, lots in it. Really interesting case. I enjoyed this one more than I was expecting to going into it. And any final remarks from you, Callum?
No, I just found it a very interesting case. There's stuff in this case that has come up a number of times in practice, and it actually creates some helpful law, particularly around speed and performance. And then there's also just really helpful guidance on the arrest points. I thought it was a very good decision. And the one thing I would say is that the saga may not be over, because there was an express reservation by one of the parties to raise a certain point on appeal around wrongful arrest. So maybe
I saw
maybe
that.
it will continue.
I
We might have
saw that.
part three.
I know. That's why. That's why I said it. I'm like, surely not. The only thing that would make it go further is costs. That
Yeah,
actually, we're not talking about 16 hours anymore. We're talking about 200, 300,000 pounds or more. It was a 4-day hearing. It could
yeah,
well have been. It could well have been more, actually, when I think about it, because you have all the costs of the earlier one, mate. I know that was decided. Those costs would have been sorted already. Look, totally agree with you. And the one other thing, I could be completely wrong about this, but someone else out there, have a look at it as well. But Para 109, and I wasn't going to mention this, but I couldn't help myself because it's a mistake I make every now and then, is I think in 109, there's reference to the claimant established. I don't know, but I think it should read the defendant established. And how many times have we sent out advices where we flip around the owners and charters, and clients come back and go, actually, don't you mean the other one here? And I thought if I'm right, and I could be wrong, but if I'm right, it's like, okay, we keep good company.
exactly. We do. Perfect.
All right,
Cheers,
mate.
Luke.
On that one, take care. See you, everyone. Bye.